I'm very grateful and thank you. I want to thank Mr. Bishop for his kind remarks. It exemplifies, I think, the kind of relationship we have in the Resources Committee, and I want to repeat that for those who in their offices maybe are not here on the floor, but in their offices and may be tuning in. I want to emphasize that the tenor of his remarks and the courtesy with which he put it forward, including his sense of humor, which is well recognized in the committee and appreciated, reflects that this legislation is not only bipartisan, it's nonpartisan. That is to say, it's not a Republican issue or a Democratic issue. It has never been presented on this floor through all the different sessions of the Congress from its introduction over the past 7 years, and it has moved through the Congress over past sessions. It has never ever been presented as a partisan issue, Republican or Democrat, and I say nonpartisan because the committee reflects the full spectrum of the left of the Democratic Party and the right of the Republican Party, whether you're characterized as a progressive or a conservative. This issue transcends that precisely for what Mr. Bishop so rightly pointed out. This bill directly affects and only affects the ceded lands and the Hawaiian homelands and the assets associated with Native Hawaiians in Hawaii. Everybody who's on the Resources Committee and everybody who has dealt with issues that have come before the body as a whole, coming out of the Resources Committee, understands that there are particular and peculiar instances associated with each member's district, whether it's salmon runs in the northeast or in the northwest rather, or whether it's water issues based on treaty obligations in the southwest, whether it's indigenous people in Alaska or indigenous people in Hawaii. Each area has particular contexts and situations that need to be addressed legislatively. And so what the committee tries to do in a nonpartisan way is address those issues in a very specific manner so that they can be resolved without impinging on any other aspect of constitutional consideration. Let me point out practically how that happens. For those of you who have visited Hawaii, when you land at the airport, you're landing on what's called ceded land. That ceded land produces revenue. Now, obviously, the airport didn't exist back when the Kingdom of Hawaii was overthrown in 1893, and it didn't exist when the United States annexed the Kingdom of Hawaii as a territory of the United States, and that airport, as it now is configured today, did not exist with the advent of statehood. And so what we have now is very, very valuable land producing revenue. And that's what this is all about. 1.8 million acres of ceded land coming in a continuum from the time of the overthrow of the kingdom down to Native Hawaii today, where the ownership and the benefits very clearly recognized, including in the Admissions Act of Hawaii to the State of the Union, Public Law 8-3, March 18th, 1959, which specifically requires us to address questions of benefiting Native Hawaiians through the lands that have been ceded to them or which were created for them by the Hawaiian Homes Commission Act of 1920. That's what we're dealing with here today. So we are asking that deference be given to the committee's work, which has been nonpartisan, which has no ideological difficulties associated with it, that deference be given to an understanding to what the Admissions Act requires of us. And I find it ironic that a support comes from Mr. Young, Mr. Don Young, as it came from other Republican chairmen. In fact, this was first introduced under Republican chairman, passed under Republican chairman, Mr. Hansen of Utah, Mr. Pombo of California, Mr. Young of Alaska, as well as Mr. Miller and Mr. Rahal, all have supported this act, as have the committees. Mr. Young is now in Alaska speaking to the Federation of Natives, of Alaskan Natives, because we recognize that there are indigenous people who are not a party to the Constitution when it was formed and first passed, but have activities and in the contemporary context, their lives affected by how we deal with it. The Constitution requires us, as a member of Congress, to be able to do that. Could I have one more minute?
A minute.
The gentleman is recognized for an additional minute.
So what is at stake here, very, very simply for the members, is this is enabling legislation. That's all it is. This creates opportunity for Native Hawaiians to take responsibility for their own actions with regard to the control and administration of their own assets. That is not in dispute. The land boundaries are there. The amount of money that's coming in is not in dispute. What's in dispute is who's going to control those assets. That's what this is about. This gives the opportunity to Native Hawaiians to organize themselves, to come back to the Secretary of the Interior, whoever that may be, and to ask the Secretary of the Interior to recognize that governing entity over these assets. If the Secretary of the Interior disagrees with it, they have to go back to the drawing board. This is enabling legislation. And it's enabling legislation that's been put together responsibly by responsible members of the Resources Committee in consultation with one another and with various administrations. And we would ask for your favorable consideration on the floor today.